Good morning, ladies and gentlemen. The first case today is Doe versus Gonzaga University. Mr. Aaron, you have reserved 25 minutes for opening, and Mr. Wiggins, of course, you'll have 30 minutes. And then Mr. Aaron, we've reserved 5 minutes for rebuttal. Mr. Aaron.
Thank you, Mr. Chief Justice, Associate Justices, and may it please the Court. My name is George Aaron, for the record, and I represent the petitioner in this matter, Rue Pastor. With me at counsel table is Laurel Sidaway, who was trial counsel and who has participated in the appeal, and sitting in the front row behind our table is Mr. Pastor. The heart of this appeal, and it's confirmed when I read the blue sheet, I think is intracorporate defamation in the state of Washington, and I want to spend a good deal of time on that. But before I do, there are two issues that I want to address because they're going to decide whether this court reinstates the jury's verdict or whether the case gets remanded for a new trial. The first issue is exclusion of a settlement agreement between Rue Pastor and a woman by the name of Julie Payton. The second issue is whether admittedly accurate jury instructions about what constitutes actual malice are deficient because they fail to further define what reckless disregard is, a component of actual malice. I'd like to talk about the settlement issue first, but before I do, I want to cover briefly some of the important facts in this case. I don't think it's necessary to dwell on the facts very much. All we need to know is the procedural posture of this case. Mr. Pastor was successful at trial and received a verdict in his favor. He was said to be a rapist. There's really no dispute about that. The jury found those kind of statements were made. The jury found that those kind of statements were untrue. The jury found that they were made with actual malice. The jury found that those kind of statements damaged Mr. Pastor, including prohibiting him from pursuing his life's work or his chosen life's work as a school teacher. Mr. Wiggins, our opposing counsel for Gonzaga, disagrees with many of the factual conclusions made by the jury and casts a fair amount of aspersions at counsel for Mr. Pastor for looking at the facts in the light most favorable to the jury's verdict, which, given the procedural posture of this case, we must do. I think in this regard, all that needs to be said is, in his pleadings before this court, there's a supplemental brief and an answer to a petition for review. There are 48 citations to the record. 43 of those citations are to the defense case or to cross-examination. Only 5 of those citations, for relatively incidental points, are to anything that the plaintiff put on as evidence. Many of the witnesses at trial and their testimony is not discussed by Mr. Wiggins, and I think that puts his approach and the disregard for the appropriate standard of review illustrates it and puts it in the proper perspective. Now, with that said, I want to move on to the settlement agreement. The settlement agreement came against the background that Mr. Pastor discovered that something was going on at Gonzaga, and he made an educational records request under FERPA, the Family Educational Rights and Privacy Act. In response to that request, he received some affidavits from Gonzaga describing in lurid detail the many things that he was alleged to have done. What it boils down to is they were claiming that Mr. Pastor was a rapist and were intending to deny him a good moral character affidavit for his teacher certification on that basis. After receiving that information, Mr. Pastor filed suit against Gonzaga and against the person that Gonzaga claimed was responsible for those allegations, Ms. Payton, the person who the settlement agreement was later executed with. Ms. Payton counterclaimed against Mr. Pastor. There were claims between them, but her defense and response to the case was, I didn't say those things that Gonzaga said I said. On that basis, a settlement agreement was entered between Mr. Pastor and Ms. Payton. The settlement agreement included mutual releases and provided for the dismissal of the counterclaims and the underlying claim without prejudice. Now, under ER 408, we know that settlement agreements are relevant for some purposes, but they're not relevant for other purposes. The general rule is that they're not relevant because they have no bearing on the liability in the case, but they can come in if necessary to prove bias or notice. Well, this isn't just a case where Gonzaga needed to keep this settlement agreement in. This is a case where Mr. Pastor faced the prospect of very real prejudice if it did come in. The trial court balanced the competing interests, Gonzaga's need for it to come in, and Mr. Pastor's need for it to stay out to avoid undue prejudice. And in looking at the law and the facts, I don't think that this court can say that Judge Cotto abused his discretion in the way in which he balanced those competing interests. First, we look at the probative value of those settlement agreements. Or first, we look at the prejudice to Mr. Pastor, rather, of those settlement agreements. If they come in, they can harm him in two ways. One, the settlement can suggest to the jury or be used to suggest to the jury, or there's a danger that the jury will believe that Ms. Payton's claims against him were valid. That would give Gonzaga a truth defense, essentially, or at least an argument that they had a truth defense in this case. The second way that settlement agreement could harm Mr. Pastor is that his claims against Payton were valid. If Julie Payton had actually said these things, that would have given Gonzaga a good faith defense to the defamation claims against it, and there was a risk that the jury would look at it that way. So he could have been harmed in those two ways. Now Gonzaga, on the other hand, says, well, we needed this evidence to prove a motivation for allegedly inconsistent statements that Julie Payton made under oath before the settlement agreement was entered and after the settlement agreement was entered. Well, the assumption underlying this argument that there were inconsistent statements is wrong. I think this was recognized by the panel in the decision below, and it was subsequently recognized in an opinion by Judge Agid, who was on the panel below, in Northington versus Sivo at 102 Washington App 545 at note 9. She said, Jane Doe's trial testimony, and Jane Doe is referring to Julie Payton, was consistent with a deposition taken before the settlement. Now, we don't need to just take the word of the panel below and the word of Judge Agid in Northington on this subject. Mr. Wiggins, in Gonzaga's appeal brief in chief in the court below, gave us an appendix that purported to set forth the conflict between Julie Payton's pretrial deposition and her trial testimony, which was also by deposition, a perpetuation deposition. He gives us a table with 8 alleged inconsistencies, but the table is incomplete. This is Appendix B to his brief in chief. And what the table really shows is his contention that Payton's testimony is inconsistent with Gonzaga's testimony. Well, that kind of is our point, that Gonzaga was reporting things that they had no reason to report happened. He only points out 3 areas, and there are only 3 where he juxtaposes inconsistent statements or allegedly inconsistent statements, pre-settlement and post-settlement. The first one involves what Payton told an advisor at GU, a faculty member at GU by the name of Kyle. Pre-settlement, she said, Payton doesn't know, or Wiggins says, Payton doesn't know if she ever told Kyle that anything Kyle said was untrue. Later, she said, I did tell her that some of the stuff wasn't true, but I can't remember specifically what it was. The second one is words that Payton was supposed to have said to another GU faculty member by the name of Sweeney. Pre-settlement, she said, Payton did not use the words assault or rape. Post-settlement, Payton did not tell Sweeney she was raped. Quote, no, not in those words. The final one, Payton describes pre-settlement, some sexual activity with Rue Pastor. Post-settlement, all she does is say, 2 years later, I don't remember exactly what happened. That is all we are talking about. There's much made in the briefing about some inconsistencies between Payton's testimony pre-trial and at the time of trial when she testified by deposition, and in the intervening time, of course, there was this settlement agreement. But the point is that there really isn't much to make over a 2-year period of any kind of inconsistency. I think the inconsistency is a much bigger problem for GU because, of course, Payton's testimony by far and away indicts its faculty members for making up things that were never said. So the first issue there, Gonzaga says, we need this, but it doesn't have any probative value because there's no inconsistency that needs to be explained. Now, having said that, settlement agreements between a party and a witness can still come in for the purpose of showing the relationship and potential bias between the party and the witness. But in this case, it proves nothing, because all this settlement agreement did was say, based on the fact that you didn't tell Gonzaga those things, we have no reason to sue you. If that fact later turns out to be wrong, it's a mutual mistake that leads to revocation or rescinding of this agreement. It doesn't, it works both ways. First of all, it's a mutual rescission, but I think more importantly, it doesn't create any right to sue Julie Payton that didn't exist before the suit. And I think that in this regard, I think it's important to consider that there was really nothing that prevented Gonzaga from arguing that Rue Pastor had the threat of a lawsuit that he could bring to bear on Julie Payton to influence her testimony. Whether or not this settlement agreement came in, he could have sued her before it, he could have sued it after. Gonzaga could have questioned her, couldn't you be sued if you really had said these things? Are you worried about being sued if you had said these things, or because you've been alleged to have said these things? And they didn't pursue any of that questioning. What they did do, though, is bring in evidence of the counterclaims, evidence of the dismissal, and that gave them more than adequate basis to argue that Julie Payton had incentive, to the extent that there was any incentive, to change her testimony, to the extent that she had changed her testimony. And that was enough. The fact that the counterclaims and the claims came in and the dismissals came in were more than enough for Gonzaga to make this argument. Balancing the lack of probative value against the potential prejudice to Rue Pastor, I don't think this court can say that Judge Cotto abused his discretion in
Counsel,
keeping
can
the
you
settlement
tell us
agreement
today what you're asking for?
I'm asking for you to reinstate the jury's verdict on all claims except for negligent investigation.
So you didn't appeal the determination of the Court of Appeals on negligence?
That's correct.
And is that because you agree with the Court of Appeals that there was not a duty of Gonzaga to investigate?
No, it is not.
Why is that?
It was not put in as part of the appeal, quite frankly, because we didn't think it was as an attractive an issue for appeal. The law is not as clear as some of these other issues, and frankly, it wasn't really necessary, a big enough part of the case to justify bringing it to this level.
So you're asking that everything be reinstated except the negligence, and you're not arguing with the decision of the Court of Appeals that went in your favor regarding the discovery issue.
Correct.
Maybe you could then move on. I have some concerns about Prins and Pate, which are the cases that I think we're particularly interested in looking at, as indicated by what you said in your opening remarks about what the issue is allegedly in this case. But since the FERPA claim is a major part of your award, it seems to me it would behoove you to speak to whether or not that claim can stand or falls, as the Court of Appeals says it must, whether you have an action under 1983, whether, as Mr. Wiggins indicates, it's subject to an exception under the regs. A few of those things would be particularly helpful, to me at least, in your remaining 10 minutes.
Thank you. I'd be glad to talk about it. With respect to Prins and Pate, the issue is not whether Prins should be overruled. The issue is how are we going to harmonize Pate with Prins. Appeals to stare decisis are not helpful in this regard. Prins said no intracorporate defamation by nature of what a corporation is. Pate allowed a claim of intracorporate defamation to go forward, but distinguished Prins on the basis that the statements at issue in that case were not made in the ordinary course. What that ordinary course reference was meant to refer to is not entirely clear. What the concurring opinion in Pate said is, well, really what we're talking about is privilege and no longer publication, and that Pate has changed the analysis with defamation by a corporate entity from one of there's no publication because a corporation can only act through its members, to given the nature of a corporation, its members have a common interest in communicating about certain subjects, but to the extent they exceed the scope of that privilege, they may be liable. Defense's argument or characterization or way to harmonize these two cases is to say there's no intercorporate publication except for an undefined limitation for ordinary course or communications outside the ordinary course. Mr. Pastor's proposed harmonizing of Pate and Prins is that the focus is shifted from publication to privilege. Now, this case, I think, presents a pretty clear opportunity for this court to decide between those two competing rules. And so what we can do, because the cases conflict, I think we've got to line up which is a better interpretation and which interpretation makes more sense. The defense gives three arguments, one interpretive type argument and two policy arguments in favor of looking at intercorporate publication as non-publication. And the first argument they make is that Pate did not explicitly overrule Prins. Well, that really doesn't address the conflict. The second argument they make is more...
Just assume, arguendo, that's correct. Mr. Wiggins' view is correct. Was this all the communication here intercorporate?
No, it was not. There's two important distinctions from both of these cases. One is the intercorporate communications culminated in an external corporate communication to the Office of the Superintendent of Public Instruction in this case. The publications in Prins and Pate were both wholly internal. The second important distinction is Pate and Prins...
I thought in Pate there was some outside the corporate family communication there. I thought the court, it's a real short opinion.
Correct. I think if I understand what Your Honor is referring to, it was to the fact, what Pate was referring to is that the communication was to two groups of employees, non-union employees and union employees, and the court remanded to make sure that some of the statements were made at least in the presence of the non-union employees, and that's based on a different rule that comes into play, and that's that you can't defame somebody to themselves. But I think that that's what Your Honor is getting at. The second distinction between this case and both Pate and Prins is that we have individual defendants here who have been sued and who have had judgments entered against them for defamation. In Pate and Prins, this court was just talking about the corporation's liability for defamation, not the individual's liability for defamation. Well, among the rationales given by Gonzaga for looking at corporate publication as non-publication is that, well, that adheres in the nature of corporations. Well, to the extent you want to extend the metaphor of the fictional personhood or personality of a corporation to the defamation context, that argument has some formalistic appeal, but I'm not sure that that's really a policy argument or a good reason to adopt the non-publication doctrine. Their final argument is we need immunity. Corporations need immunity. Well, they don't explain why they need immunity any more than any other type of business organization, such as a sole proprietorship or a general partnership that doesn't have an identity that's separate from the component members, but they do say that we need immunity. That's what you've got to weigh on Gonzaga's side. On the side of looking at intercorporate publication from the perspective of a common interest privilege, has a lot more that weighs in its favor. For one thing, it avoids some of the uncertainty that looking at corporate publication as non-publication entails. It entails uncertainty because we don't know which business organizations, whether it's just corporations, whether it's business organizations that are certificated by the Secretary of State and have some sort of separate identity, and we can use the same sort of personhood analogy. We also don't know, another area of uncertainty that's engendered by Gonzaga's approach is this ordinary course exception that they contend was created by Pate. To the extent this ordinary course exception exists, it cuts against their policy arguments of preserving the corporate form and giving corporations immunity to have unfettered discussion. To the extent that they read it narrowly, well, it's not really an exception at all, and they're reading it out of Pate. I think this kind of uncertainty contrasts sharply with what we've got in terms of well-settled law of common interest privilege. In addition to the uncertainty, though, I think we've got some conflict that's engendered by their interpretation of PRINs with some other areas of law, and I think of two in particular. One is agency law, and that is, if to the extent that PRINs extends to immunize the individual component members of a corporation, the rule in defamation then becomes different than any other tort, because the restatement of agency tells us that in their dealings between themselves, an employee's relation to fellow employees is the same as it is to third persons, even though their relationship to the corporation may be as just a component part. And normally we do have individual liability for defamation, and there are cases cited in the materials that suggest individual liability for defamation is appropriate.
Counsel, if I could interrupt, even assuming that there is a qualified privilege, that privilege, of course, can be lost if there is actual malice, right? Gonzaga is indicating that the instruction on that was deficient. I'd like you to respond to that, please.
Well, they don't indicate that the instruction was wrong. Mr. Cartwright, trial counsel for Gonzaga.
Deficient.
Correct. They say that we should have gone farther, the trial court should have gone farther in defining what reckless disregard is. Now, initially, I think that there's a real preservation of error problem, because and it's interesting that Gonzaga doesn't defend it much on appeal, but the reckless disregard instruction that they propose is wrong. It encompasses reckless disregard by commission, but as Judge Cotto says, it does not address reckless disregard by omission. And you can have both. Their instruction is wrong, and CR 51 says, if you're going to complain about a jury instruction, you have to propose a correct one. Now, the Court of Appeals recognized this preservation of error problem and said, well, because this is a speech issue, we implicate the First Amendment, and we get into the exception for normal preservation of error problems based on error affecting a constitutional right. That doesn't apply in this case, because this isn't just a simple case of failure to preserve an error. It's more like an invited error. And I don't know if there are any cases specifically saying that proposing an incorrect jury instruction is invited error, but what Gonzaga invited the trial court to do was to instruct the jury incorrectly about what reckless disregard was. And the normal exception to preservation of error for constitutional rights does not apply to invited errors. But moving beyond that, there is no case, and none cited by Gonzaga certainly, that suggests that the failure to define reckless disregard constitutes reversible error. Especially where the rest of the definition is admitted to be accurate. Now, when you look at the merits of their complaint, they say it allowed the jury to hold Gonzaga to an objective standard of reckless disregard. I disagree, and I think that this court has to disagree based on what the text of the instruction says. The instruction...
Counsel, you're into your last 5 minutes and you haven't started with FERPA yet, so...
That's correct, Your Honor. And I appreciate that. Thank you for the reminder. The jury instruction is worded in terms of what the defendant knew or whether the defendant acted in reckless disregard. There's no problem with inviting the jury to hold Gonzaga to an objective standard as to what Gonzaga did with this jury instruction. That, coupled with the absence of authority on the point, is, I think, dispositive. Justice Ireland, is there a particular part of the FERPA claim that you'd like me to address first?
Well, I think that the primary defense in the supplemental briefing I read is that there's a regulation here that creates a waiver, that once Mr. Pastor applied for his certification as a teacher, he comes under that regulation, waiver, Court of Appeals is correct, your FERPA claim falls, even assuming that you met your FERPA claim.
And I'd love to address the waiver issue, because I think it is, from our perspective, it's exceedingly clear. FERPA says in order to waive your FERPA rights, this is in the statute, and I believe it is 20 U.S.C. Section 1232G says you have to have written consent in order to waive your FERPA rights. then the Department of Education has promulgated a regulation at 34 CFR section 99.30 that prescribes the exact form of that written consent. We do not have that written consent here. It is the Division 1 did not have the authority to find a waiver under the Washington Administrative Code without Gonzaga complying with the federal statute and the federal regulation. The Supremacy Clause preempts any kind of state law waiver
But I don't
analysis.
think that's the argument that they make. They're not talking about, well, there was an implied waiver under 9930. They're saying that 9934 gives them the right to infer waiver when the plaintiff makes his application. At least that's how I understand the argument.
And I don't think that there's any basis in the regulation or the statute for that kind of an argument.
Well,
I don't know that there's...
Do you agree that the regulation says that there is an exception for when they are dealing with a body that is looking at the certification in subsection 7?
I don't believe so, and I don't have the regulation in front of me, so I can't address that in particular. With the FERPA,
You're in your rebuttal time. You can choose to do that if you wish, but
I will go ahead and sit down and reserve the remainder of my time. Thank you, Your Honor.
Mr. Wiggins, before you start, I was somewhat negligent in the performance of my duties as Chief Justice in not introducing our pro tem judge here today, Judge Stephen Brown. I apologize for not indicating that at the outset of the argument. Judge Stephen Brown, as many of you know, is a former judge of the trial judge in the Yakima County Superior Court and currently a judge at Division 3 of the Court of Appeals, and we're pleased that you're able to sit in with us today. Mr. Wiggins.
Thank you, Your Honor. May it please the Court, I'm Charlie Wiggins, here representing Gonzaga and the individual Gonzaga defendants. With me at counsel table is Mike Casey, corporate counsel for Gonzaga. We are here because in 1993, the dean, or in 1994, the dean of Gonzaga's School of Education learned of allegations that the plaintiff in this case, John Doe, had forcibly engaged in sexual relations with another student, Julie Payton. Now, Dean McGuigan could have stuck her head in the sand. She could have ignored all of this. She could have given Mr. Doe a clean moral character affidavit. But instead, she opted to protect the school children of this state by saying, I'm not going to give that affidavit. Now, Mr. Doe had a remedy. He could have gone to SPI and said, I can't get an affidavit, but you should give me the certificate. And we know from the testimony of SPI that they would, if no one came forward, they would have given him the certificate. He chose not to do that. Instead, he sued Gonzaga. That is why we're here.
But Mr. Wiggins, he didn't sue Gonzaga for not giving him a certificate, did he? He sued them for all the things they said to all the people they said it to in the process of deciding that they weren't going to give him an affidavit. Isn't that true?
Let's focus on all the things that were said. That is exactly the heart of his claim. His damages are the failure to give it, for him to get the certificate. That's the primary thrust of his damages. But that is it. It's the allegedly defamatory statements. But let's focus on this because I disagree with the characterization of my opposing counsel here about these statements.
Well, didn't this all begin by one of Gonzaga's staffers, not the dean, not a faculty member, one of Gonzaga's staffers, eavesdropping on a conversation?
Bobby League is the certification specialist in the School of Education. She did overhear a conversation as she walked through the room. She could have ignored it, but her responsibility at Gonzaga is to coordinate teacher certification. So instead of ignoring it, she raised the question with Professor Kyle, Dr. Kyle. They were concerned initially because John Doe was in his student teaching. And their initial question was, is this something that really puts kids at risk here and now? But then Bobby League was concerned about it from the certification standpoint as well. She called Adele Noor at SPI. Now, it's very important to distinguish between the external communications with Noor and the internal communications among Gonzaga, because the Prince doctrine protects the internal communications, but not the external communications. And Ms. Noor's notes of her first conversation with Bobby League are here. And they are basically, we've heard this, here are the allegations, and this is what's important. She records in the notes, they're getting different viewpoints from everyone. They don't know now how much credibility to give the accusations, told her to talk to the girl, get the information, then they can assess credibility. Now
this is Miss Noor who's saying she told
League
to talk to the girl.
Correct. Correct. Now,
did she also tell her to talk to the boy?
Exactly. She does that. And you'll see that here in another part of her notes. And what she says is this: until they talk to the alleged victim directly and then to the student himself, it's still all an unknown.
But they never did talk to the student himself.
No, they didn't.
Ever.
They didn't. And why didn't they? That's an important fact. They were going to talk to him. And then Julie Payton, the victim in this case, begged them not to. And Professor Sweeney learned that she was despondent. She was hiding literally under her bed in the dorm. She didn't want them to talk to them. She was terrified of this man. And in fact, she had told Berkalow that she was afraid of him. And that's when they decided they just couldn't talk to him. And that's why they didn't. But the other defamatory communication, or allegedly defamatory communication, is this rather cryptic note. These are very highly redacted notes of Ms. Noor. Dr. Kyle, Bobby, and another person who had come forward, apparently referring to Lynch, talked with the girl. She is very articulate, willing to come forward. They will get her statement. Well, they never got her statement, as you've pointed out. They never got his statement.
But they represented to Dr. Noor that she was willing to give a statement, didn't they?
Willing to give a statement. And what Noor also told them was, until you talk to the girl and until you talk to the man, then you can't, it's still an unknown. They will get her statement. What is the implication there? When you get her statement, you're going to know the facts. This is not defamatory in the sense that this means these allegations are true. It is, they will get her statement, and they never got her statement. Now, the internal statements, I think there was a misstatement by opposing counsel. The internal statements, internal to Gonzaga, were never given to Noor. None of that information was given to anyone. The internal defamatory statements we're talking about are 7 documents. They are 7 exhibits that were prepared months after these conversations in February of 1994 at the request of Dean McGuigan. And why did McGuigan ask for them? Because she was making a decision about the moral character affidavit, and after she met with these 7 people, she said, please make a record of what you've told me, and she put it in the file. These were not disseminated. They didn't go anywhere. No, they wouldn't have seen the light of day but for the fact that John Doe got them from the university and brought this lawsuit. So we are squarely within the Prince doctrine. Now, these statements, there are...
Before you start talking about Prince, can I just ask you one thing? Are you saying that there was a duty to investigate on the part of Gonzaga?
No, there was not.
Because I'm somewhat confused about your position in that regard with regard to the defamation versus your position in that regard when you talk about FERPA. Because in your FERPA argument, you claim that Gonzaga was doing its due diligence, which would seem to suggest to me that they had some sort of duty to investigate. At page 23, you say the disclosures to OSPI were part of Dean McGuin's due diligence and were expressly authorized, although not required, by this regulation. And you're referring there to I assume you're referring to the WAC regulation.
You could address my question at the same time, which it appears to me, at least below, that you argued that there was no negligent investigation because there was no duty to investigate. Yet on the invasion of privacy issue, it would appear that you argue that he identified himself as a candidate for teaching certificate, and therefore the university was authorized or required to investigate. And maybe you can harmonize those two positions for me.
What the dean was required to do was to decide whether to give a moral character, a good moral character affidavit. It's very clear from the testimony of everyone at OSPI, and that's Ms. Knorr, and it's also the counsel for OSPI, that Gonzaga had no duty or even expectation that they were going to make a determination or an investigation. They weren't going to try these allegations. All they were going to say was, does she have enough information to give a clean moral character affidavit? Now let me I want to put up the regulation because I think that really relates to this question of what duty there really was. This is what the dean had to say, that she had contacted several faculty members who personally knew the applicant and had no knowledge the applicant had been convicted of any crime and has no knowledge that the applicant has a history of serious behavioral problems. Does the dean have to make a determination of the truth or falsity of that information? No. All she has to say is whether she has any knowledge of a history of serious behavioral problems. But she was not under any obligation, and she didn't undertake to decide, is this true? Her goal was to decide, is there enough here that I should not give this affidavit? And that accounts for the telephone calls between OSPI and Bobby Lee. They were trying to make that determination. Now, there's something else I want to say about this. There is a lot of evidence from Julie Payton that this sexual assault happened, not just once, but repeatedly. She told the doctor and the nurse that it happened immediately afterward, not immediately, within a week. She filed an answer to John Doe's complaint saying that he sexually assaulted her. She testified in her deposition that this occurred, that sex without consent occurred. There it is, the last 4 lines. Were you objecting to the contact that took place prior to the sexual intercourse? Uh-huh. Is that a yes? Yes. Now, the statement was made by my opposing counsel. There is no difference between the pre-settlement depositions, this is a pre-settlement deposition, and the post-settlement deposition. I don't think we need to get there. I think we need to talk about Prins, but I do want to make this point very briefly. This is a pre-settlement deposition. Here is what she said post-settlement. Now, apparently, since at that point you told him you didn't want to have sexual relations with him anymore, how was it you ended up on the bed with your clothes off? I don't know. Is it a fair statement at that point you didn't want to have sexual intercourse? Yes. Did you let him know that? I can't really remember all the details and everything. Now, was there sexual intercourse? I think I have to say so. I really just can't remember the whole thing. I just can't. Now, what is a jury supposed to conclude from this kind of testimony? They certainly aren't going to think that there was forcible compulsion. Any woman who has been subjected to that kind of compulsion is going to remember it. She's not going to have this kind of memory lapse. So what possible reason is there for this memory lapse? The reason is the settlement agreement. The settlement agreement bought her silence. This man told her not to tell about this incident. That is what she told Kyle. That's what she told Berkalow. And he ensured her silence by suing her and then entering into an oppressive settlement agreement. And I stand on the position that her testimony changed. She backed away from her testimony. She gave this kind of testimony. Now,
Mr. Wiggins, Mr. Aaron says that you were confronted with a record that allowed you to argue this to the jury in the form of the counterclaim was admitted and the fact of dismissal Are you limited in such a way as to prevent you from arguing your theory of the case based upon this one evidence ruling?
What is the message to the jury that there has been a dismissal of a claim? It is that John Doe no longer thinks that she made these statements. She no longer thinks that he abused her. That's the message to the jury. In fact, there is a subsurface fact here that we were never allowed to put in. Now, I want to caution you about the petition for review. There's an appendix to that petition for review in which the plaintiff's counsel has interwoven actual excerpts of testimony and then said, oh, and he could have said so-and-so. He could have asked thus and such. That's not in the record, the could have asked. That's not there. I just say to you, I think we all know that if a jury hears that someone is dismissed out of a case, they have no incentive to lie. They have every reason to tell the truth. But the fact is, in this case, exactly the opposite was true. And it was especially true because there were two witnesses who came forward during trial and said, she told me about rape, one of them said. She told me about forcible compulsion, the other one said. And so now the jury they didn't know that either. So both of those facts were critical facts that the jury didn't have. Moving on to Prince. This case is within the heart of the Prince doctrine. How is a corporation supposed to function other than having employees talk to one another and create an institutional memory? That's what these memoranda were. Not memoranda, declarations, these 7 declarations. They were not disseminated to anyone, and in fact, if you read them, they do not say, I conclude this is what happened. They say, this is the conversation that I had. This is what Julie Payton told me. Sweeney's declaration is a good example of that. He says, she came to me, here's what she said, and it goes on and on and on. He doesn't say, and I conclude from this John Doe raped her. Now, was that information published? Was it disseminated to someone? Certainly not. That is the holding of Prince. Now, Mr. Aaron says, we are not here to decide whether to overrule Prince. That's exactly what they're asking you to do. You cannot sustain Prince and sustain this verdict. It's just not possible. And so the question to you is, under the doctrine of stare decisis, has Prince and the Prince rule become so harmful or so prejudicial that it should be changed? And the answer that I offer is no, it is not.
Counsel, let me ask you a question about that. First of all, in Prince, there was absolutely no question that the people involved were within the ordinary course of their work, correct?
That's correct.
Nobody made any allegations that they were outside the ordinary course of their work. So that issue was never addressed in Prince, was it?
No. I mean, that was not part of the Prince case.
It's not part of the case.
That's correct.
So isn't it a leap to say absolutely, to interpret Prince to say absolutely under no circumstances can there ever be a communication between members of the same workforce when the workforce is in the corporate form? Isn't that stretching Prince? I mean, I realize that's how you'd like us to read that case.
Well, I think you have to read Prince in light of Pate. There's no question about that. And the Pate case added a refinement to the Prince rule, which is that it has to be within the ordinary course of the duties of the person. Now, is there any question in this case that these statements prepared by the faculty members at the request of Dean McGuigan were within the ordinary course of their duties? Absolutely none.
Did you get summary judgment on that?
We moved for summary judgment and it was denied. We moved for discretionary review.
Wasn't it a question for the jury?
It was not submitted as a question to the jury because what the trial judge said was Prince is not good law. I'm going to, he said, quote, throw Prince out the window, end of quote.
But wasn't the instruction that the court gave perfectly in line with the Pate decision, which, as you say, is nothing but a refinement of Prince?
I don't know what instruction could have allowed us to argue the Prince doctrine.
Well, you couldn't have argued the Prince document because the Prince document is, because you just conceded that Prince has been refined by Pate.
Well, I'm losing the train of thought here, Your Honor. The law is that if a statement is made within the ordinary course of an employee's duties, and it's made intra-corporate, that it is not published. That's the Prinz rule as refined by Pate. We moved for summary judgment on that. It was denied.
Did you get an instruction that said what you just said?
No, we proposed a Prinz instruction, and it was denied. That was really, it's not just the summary judgment, it's the Prinz instruction wasn't given. And that's what led us to the Court of Appeals. We came here, we sought discretionary review of that decision. It was denied, of the denial of summary judgment on that. And so there we were at trial. There was no possibility of submitting that to the jury.
And what, assuming that, I mean, the Prinz case is still out there. It's not been specifically overruled by any decision.
No.
What would be, in your view, and you're suggesting that if we go in the direction of your opponents, that we will really be overruling Prinz? I think you.
That's right.
What do you think the effects of that would be in the corporate world? Nonprofits like we have here, or profit-making corporations?
Let's take this case. I think the message, what the WICA, the Washington Independent Association of Colleges and Universities, is telling you is that the message to them is going to be, don't look into these things. Hear no evil, see no evil, speak no evil. Ignore this, stay out of trouble, give a clean moral character affidavit. Because think about what their theory is. Their theory is the minute you listen to someone who tells you about accusations of improper conduct, and you write it down, and you put it in your file, and you show it to another employee or to the dean, that's a defamatory communication. That's their theory. Now, what message is that going to send? You better not investigate. You better keep your nose clean. Stay out of it. Let OSPI worry about it. That's a terrible message to send. And how...
You think if this circumstance had been that the alleged victims had come to Gonzaga rather than somebody overhearing our conversation, which was, I think, the way this started, you think that in the future there would be a chilling effect on them even looking into this?
Absolutely. And I don't think it's limited to universities. I think it's true of corporate investigation of sexual harassment. The same problem is going to occur in the corporate context.
As a matter of policy, should we elevate corporations over all other forms of business organizations, such as partnership and sole proprietorship? There are some large sole proprietorships.
I think that is an excellent question that's not really presented here. I think that the logic of Prinz in this type of situation should probably extend to a partnership, for example. But we don't need to reach that today. I don't think the idea that if Prinz is a good rule...
How does the logic of Prinz extend to a partnership, or more pertinently, to a sole proprietorship? An agent, all these entities act through their employees, true, but the argument in a corporation is that anyone who acts on behalf of the corporation, so there's only communication with oneself. How could you extend that to a sole proprietorship?
Your Honor, I don't know whether Prinz should be extended to a partnership. It's not presented by our facts. But if it's a good rule, it doesn't become a bad rule because it's only a rule for corporations. I think that the question you really have to look at is this: how do you balance the need for corporations to communicate internally, to investigate allegations of misconduct, and to take whatever...
By doing what Pate did, looking at a qualified privilege, which is the terms that are discussed in Pate, which, as you indicate, is a refinement of Prinz. Was there a qualified privilege? Did it apply in this situation? And that's what the court instructed on.
I disagree with that reading of Pate. That's not what Pate says. Pate says Prinz cannot be extended to statements outside the ordinary duties of the employee. That's what Prinz says. And in that situation, you're only talking about qualified privileges. That's the holding of Prinz. or Pate. Pate doesn't say what Prinz really meant was we're only talking about a qualified privilege. There's a concurring opinion. 1 judge out of 5 says that.
I agree that Pate doesn't say that's what Prinz meant, but you acknowledge that Pate is a refinement of the Prinz document. It didn't overrule Prinz, but it said we're looking at, was the person within the ordinary course of their work? Did they fall within the kind of privilege that is necessary for businesses to conduct their business?
Was it a communication if it's outside the ordinary course of their work? That's what the Pate case says. Now, if you're going to apply that test to this case, what possible argument can there be that these people, when they made these statements or were requested to make these statements by the dean so that she could decide that this is a moral character, whether to give a moral character affidavit, what possible argument can there be that that was outside of her duties or that it was outside of their duties? The regulation says she's supposed to go talk to the faculty members and find out. She did that. Now, how could that be outside of her duties? How could it be outside of their duties? It's not. And
Counsel, can I go back to the question that Chief Justice Alexander was raising, having to do with the potential chilling effect?
Yes.
Of taking the plaintiff's position in this case. You indicated in the circumstances here there was no duty to investigate, but there is a duty to investigate when there is an allegation of sexual harassment that is brought to an employer. So how would investigation be chilled when in fact there is a duty?
Well, I think that an employer who's going to have to be looking over their shoulder thinking about, am I going to be sued by the person who is accused if they get into my internal files and get hold of these, I think there is going to be a chilling effect in how carefully they're going to investigate and what they're going to record.
Well, they have to be careful. What's wrong with that? Because these are very serious allegations. Why shouldn't they have to be careful?
Of course they should be careful. Of course Gonzaga was careful. That's not the point. The point is that the very act,
Can you say it was careful when they didn't even talk to the person who's the alleged subject of all this?
Well, Your Honor, the problem is, what are they going to say to him? They can't name Julie Payton because she won't come forward. They're afraid that she is despondent, literally hiding under her bed, and she is terrified of this man. And she's told them that. Now, they didn't say to OSPI, we've got a rapist on our hands. They didn't say that to anyone. All they said to John Doe was, we're not going to give you this declaration. We're not going to give you this affidavit. They didn't disseminate any of this. Now, how careful do they have to be? You're talking about, did they have to talk to him? Maybe if there were a duty to investigate in the private enterprise sector, maybe they would, but not here. But I still say I think that there is a chilling effect there. And I think the question is, how are you going to balance that chilling effect against the right of a plaintiff in this situation to go forward and be able to present evidence of actual malice and actual falsity? How often are they going to be able to do that? And what's the deterrent of the expense of defending a case like this? Because it's hard to get summary judgment on these cases. Certainly there are summary judgment cases, but...
Excuse me, Mr. Wiggins, we've been talking about the Prinz Doctrine, Pate, how it may refine it, intra-corporate communications. In that context, how does Gonzaga deal with the problem of the publication to Knorr, who is not within the corporation? How does that fit within that particular doctrine?
Well, the way Judges Applewick, Agate, and Ellington dealt with that is to segregate her out, which is correct. She's not within the Prinz Doctrine. She's external to the corporation. And what were the statements made to her? Now, the way this was presented to the jury, because the trial judge wouldn't give us a Prinz instruction and wouldn't limit this, it all got jumbled together and handed to the jury as one big bag of accusations. Now, what Judges Applewick, Agate, and Ellington said is it's got to go back for retrial as to Knorr on these very limited statements. They are very limited. None of the internal statements were given to Noor. And so that's the way it was dealt with. That's the way it should be dealt with.
But the Court of Appeals didn't say you get a Prince instruction.
No, they said those internal statements are not actionable. And, you know, a jury is going to have to be instructed. The question is, are these statements to Noor defamatory? Frankly, none of them are defamatory, in my opinion. And the reason they're not defamatory is it's not defamatory to call someone a cocky male chauvinist. That's an opinion statement that's not defamatory.
Are you saying that accusations of sexual assault is not defamatory?
Well, what she was told is, we have these stories. She was told, we don't know what to make of it. We don't know how to assess credibility. She said, talk to the girl, talk to the perpetrator, and then you'll know where you are. But until then, it's all an unknown. That's what she was told. That's what she concluded. Is that defamatory? I don't think so. Is it defamatory to say the girl will come forward, we'll get her statement, and then they'd never get the statement, and Noor doesn't know what the statement is? But that's a different question. That's been remanded, or that's
and that's a question for the jury.
That's a question for the jury. Now, the actual malice instruction, I'll deal with that very briefly because I'm running out of time here. But on the actual malice instruction, the problem with this instruction is that it simply doesn't define reckless disregard. And reckless disregard is not something that an everyday term that jurors are going to know necessarily implies a subjective element. Now, it was objected to by the defense, and what is most interesting is that it was objected to by the plaintiff. Ms. Sidaway, trial counsel for John Doe, said, Your Honor, we had asked for an elaboration of the definition, reckless disregard. If you define the term, it's equally acceptable to us. And what did the trial judge say? He said, no, argue your interpretation of the law to the jury. Now,
counsel, if you go back to your instruction that you just showed us, isn't that actually an instruction of a knowing false statement, not a reckless disregard?
What that definition says is if you know of information which would render the statement false. In other words, if you know that there are facts, fact X, and it renders fact Y false, then you're acting in reckless disregard even though you don't know that Y is false.
But the court rejected your statement because your statement is a statement that is making a knowing false statement. In other words, it's not defining a reckless statement.
Here's the problem, Your Honor. When both sides of the case ask for a definition of a term like this, which is a critical definition in a case like this, and the judge says, I'm not going to give any definition, is that error or not?
But what about when one side doesn't give a definition, which the plaintiff didn't offer their own definition of reckless?
They actually did offer their own definition.
And was it defective in your view?
I think it was defective as well.
You claimed theirs was defective. They claim yours is defective.
Exactly. Exactly. Now, is there law on this particular? I don't know of a case. May I continue?
As long as you're answering her question, I'll let you continue.
Okay. Thank you.
Well, I think you have answered it.
Okay. Thank you very much.
Your time has expired. Mr. Aaron, you have 4 minutes.
Thank you. There's just a few points I want to address.
Counsel, if you could perhaps tell from my question to Mr. Wiggins, I am concerned about if the court disturbs the Prin's opinion very much, that we may be putting a chilling effect on the willingness of nonprofit or profit corporations within the family to discuss issues that they should discuss to investigate serious allegations of serious misconduct that they should be concerned about. Is that something that I should be concerned about?
Absolutely. And in this context and in other contexts, we provide protection for that through the qualified privilege. We limit our absolute privileges because we know that it's just not right to completely deprive individuals of the normal incentive that accompanies tort liability to engage in unfettered discussion to the detriment of whomever, no matter how bad it might be. And so we in circumstances like this, we give defamers, if you will, a common interest privilege or other form of a conditional qualified privilege. That privilege must be abused before a defamation plaintiff can recover. The abuse has to be proven with evidence of actual malice, and it's subject to a higher burden of proof. It's got to be proven by clear, cogent, and convincing evidence. It's unclear to me from Gonzaga's argument why more protection than that is necessary, and why more protection should be given to corporations than any other kind of organization that doesn't have this separate legal personhood. And so your concern is entirely valid. It's already been addressed. The law of qualified privileges is much more definite and certain than trying to expand upon the ordinary coarse language in the Pate decision, rather than recognizing it, as the concurring opinion did in Pate, as an indication that it was a qualified privilege that the court was really talking about. There are some facts.
So what rule of law would you have us adopt?
Intercorporate communications are subject to a qualified common interest privilege or other applicable common interest privileges. For example, in this case, there's a statutory qualified privilege that goes along with making reports to a government agency. And the jury was instructed on both of those privileges in this case. And of course, the jury found that there was actual malice, abuse of those privileges sufficient to overcome them by a clear, cogent, and convincing standard of review, or standard of proof. I want to dispel the notion that the 7 affidavits in the record from Gonzaga personnel are the internal defamation. They are merely evidence of the internal defamation. There's a chronology, which is, I believe, Exhibit 28, that details how much these allegations were passed along, to whom, how broadly they were circulated within the Gonzaga community, and it's not just 7 affidavits that we're looking at that is the defamation.
Counsel, did you have an opportunity to look at 34 CRF subsection 7?
I did not, Your Honor, and I apologize for that.
Okay.
I don't have it at counsel table. A final thing that I want to...
But I take it you do oppose an instruction that a communication within a corporation is not a publication. You do oppose that. You would oppose an instruction that said that.
Yes, we would.
Even though that is language from Prinz, is it not?
Yes, as unmodified as Prinz, of course, was by Pate as well. The thing that I want to leave with is and the reason that I concentrate on the settlement agreement and the actual malice instruction, as Justice Bridge was asking about, is this case, by the time it gets back to trial, if I may conclude briefly.
You may wrap up. I'll give you about 30 seconds.
Assuming we get to trial next year, we're going to be dealing with 10 years of time passed since these alleged acts that gave the rise to the defamation occurred, and it's going to be a monumental task for anybody, defense or plaintiff, to try, and I think that the proper level of respect for the jury's decision is necessary to avoid that problem. And I thank you.
Thank you, counsel. Court will be in recess for 10 minutes.